I think
My name's Yasmin. My company is Company Select UK, and I'm based in Stafford Park in Telford. And what I do, I do different kinds of legal, but mostly I am a credit legal representative for Companies House. But today we're not going to speak about Companies House because on the table I have prepared some leaflets for you, but on the back, if you look, it will give you an indication of what we are going to talk about and why, okay? Now today I thought within the 10 minutes that I have, it has to be very brief but very, very concise on how we got to represent this. Now the 3Ds represent the most important 3 documents that you require within your business and within your personal life. So can someone tell me, let's start with businesses now, those who have a limited company in the room and those who have more than one shareholder in the business, do you have a shareholders agreement? Put your hands up to let me know. So it only shows 2 people within the company who's got shareholders agreements. Now a shareholders agreement within a business indicates, you could say, like a will. It will indicate when you have dispute resolution. So if we've got shareholders and you have more, it allows you to, it gives the extra protection within the company if somebody wants to sell your shares. Because without a shareholders agreement, I can honestly tell you the amount of disputes that I have dealt with over the years is phenomenal. Now, having a shareholders agreement in a company is not a legal requirement. It's at your own choice. But if you have something there, prevention is far better than any cure. And it's just one-off cost and you've got it there as long as you've got your limited company. So if it's something that you're looking for within your limited company and you have more than 2 shareholders, I would personally and professionally recommend that you get something drafted. It will also give you an indication, so if sadly, if someone were to die, what happens to the other shareholder shares? It means that it will go to the next of kin within a will. Then you have shareholders in your business who knows nothing about your business and you're really in a bit of a predicament, okay? So having something like that in your business is really, really crucial. Now, moving forward, what I would also like to discuss with you, like I said, we're discussing the 3Ds, the 3 documents. The second document I'd like to discuss with you is your will. Who has a will in the room? Perfect. There are 70% of people in the UK that don't have a will. And again, it's not compulsory to have a will. But do you know what happens if you don't have a will? All your wishes, if you've got an estate worth lots and lots of money and there's no will, then really you're going to be in trouble because we have to provide a representative to be able to apply to the courts to be able to do the probate for you. And it takes time and it costs money. Money that really you won't be able to afford if you have to pay the probate before you are granted all of the assets. So again, they don't need to do a will because their next of kin will automatically inherit. They don't inherit. So therefore, by having this, you know that your wishes will go to the people that you want your assets to go, like for houses, for example. Now, another thing to consider, if you live together, cohabitation, you haven't been married and you have children and the partner dies, you get nothing. Absolutely nothing. because you don't have a will. Hello there! Morning! That's okay. So in essence, having this document in place, again, is not a legal requirement, but it provides the peace of mind for your loved ones when you decide to leave. Okay? And it is sad to say that the government will inherit your estate if we can't find any blood relatives in relation to your estate and yourself. So, two crucial documents so far that are not legally required, but are the most important document you could have in your lifetime. Okay? Now, moving on to the third document, having a whole week wouldn't be enough to explain to you about all this, so I'm trying to bam everything, so it gives you an indication. Now, does anybody know what an LPA is? Lasting power of attorney. Not many of you. But those who do know what a lasting power of attorney is, I'm assuming that you have one. Good. Now, lasting power of attorney, there are several actually. The first one was the enduring power of attorney, which can only be used when you lose capacity completely. Right? That's when the enduring power of attorney comes into force. But to make life a little bit easier, in 2009, the Public Guardian created two separate lasting power of attorneys, one called financial property and the other one is health and welfare. When you register an LPA, it takes 20 weeks, by the way, to register, so if you're looking to register them, be aware that that's how long it will take. An LPA represents an attorney. So for example, if we use you, Gareth, as an example, okay, and you are my attorney, because I'm the donor, you become me. Whether I've gone gaga or not, I give you the authority to act on my behalf, which means that the property and financial affairs document we would take to the bank, register with you, and if you needed to take money out on my behalf, you are legally required to. Now, if you don't have an LPA and you're looking after people and they ask you and they give you their card, or go and get me some money out of the bank, you can't. It's fraud. Because you don't have the legal authority to do so. So by having that in place, it allows you to help them with their finances, talk to welfare people, with their pensions, anything to do with their accounts that has their name on there, you are legally obliged to act on their behalf, right? Now the other LPA is a health and welfare. Again, you discuss this with the doctors and the nurses and the hospitals. If someone has to go into a home, you might think, I don't like that home. But if you don't have an LPA, they will go where the doctors take you to go. But if you have one in place, you can choose, you can do anything, because you have the power to be able to have their own voice. And it's really important that when choosing attorneys for your lasting, for your LPA, that they are trustworthy, okay? We have, at the moment, I'm just inundated with disputes with LPAs, people removing attorneys off the LPAs because one's not doing this, the other one's not doing that. So it's had to go to the protection court because there's nothing else that I can actually do. If that certain person needs to come off the LPA, they've got to go to court because it's gone too far. So looking at it in a perspective way with businesses and life, I was 27 when I did my will. And the reason I was so young is because I bought my property. So God forbid something could have happened and my mother would have inherited my property, for example. But having your documents in order, you can't go wrong. It's the same with business. You've got business people, you're working together harmoniously, then it goes boom shakala, and then you're in a predicament. So, based on everything that we've discussed about, do we have any concerns in the room about what I'm actually talking about? Yes, Alex.
My dad is 96 and his brain is slowly declining.
Okay.
Is it still possible to put something in place or not?
Are we talking about a will or an LPA?
An LPA.
Okay. Bearing in mind, it takes 20 weeks to register, and sadly, you know, God forbid that something might happen to him in those 20 weeks. An LPA is not going to be the result. You need a will.
No, a will I have.
Okay.
Well, but it's LPA, more about the capacity to make decisions on his behalf.
You would have to get a confirmation from the doctors that he's capable of signing his LPA over, and who the trusted attorneys are going to be. But if it's slowly declining in those 20 weeks, we don't know. You won't be able to do anything until it's physically registered. So whether we send it off to register, you still can't do anything. So thinking of time and money, you know, who knows what's going to happen. But unless you actually have confirmation from the doctors to say that he's got total capacity, then that's fine. That would be your choice to take that forward. But otherwise, you're going to be a bit in a predicament, Alex. Sorry, you know. But can you see why it's important? This is why I'm very, very bang on trying to tell people that it's your choice. You don't have to have these documents at all. But if you don't...
Yasmin, can I just...
Of course.
I had a friend who was hit by a car on his bike. He did die. He was quite young. He had 2 very young kids at the time. No will. And it basically left the family destitute. The wife and kids absolutely destitute, because she was relying on his work and everything else, and everything was obviously slapped down and they couldn't locked away and everything else. So for months and months and months, they couldn't do it. So that's one thing that really always hits me, because I saw how desperate they were at the end.
Yeah, and this is why having an LPA in place, it's...
Or will, or just something.
An LPA comes into force while you're alive. So while you're breathing, then we'll use an LPA.
Yeah.
One thing I didn't realise that I found out recently was if you're married and you get divorced and then you don't remarry and you haven't got a will or a lasting power of attorney in place, your former spouse can have a claim in your estate.
Of course they can, because if you remarry or you divorce, it's imperative that you change your will. Always. Because things happen, children, people come out of the woodwork, especially when you haven't seen people for so many years. They hear about, oh, sadly, so-and-so's died. I'll give you a very example, and this will give you shivers down your spine. My Uncle Dennis, bless him, he died. I managed to do their wills and their LPAs well before they passed. Now, because Uncle Dennis had married my Auntie Tony, Uncle Dennis only had one son, that son had a child. But when Uncle Dennis and my Auntie Tony got married, his son didn't want to have anything to do with his dad. So in 25 years, he hadn't seen his son or his grandson. When they hear that Uncle Dennis died, 6 months later, my mum gets up and knocks at the door. Oh, and it was the grandson. I hear that my granddad has died. My mum turned around and said, well, I'm not going to say exactly what she said, because that, you know. She turned around and said, well, you're 6 months, a little bit too late. Shut the door. And it's sad when these things happen. So for the sake of just signing a piece of paper to give you peace of mind, your family peace of mind, and everybody that you care about and love about, it's just so important. Yes, my darling.
I was going to ask if you set up an LPA and somewhere down the road you decide that you don't want the person you've nominated to be
In your LPA.
Yeah, your LPA. Can you change it? And if so,
If we've got two people on an LPA, so they're called attorneys, okay, and you want to revoke one, take one off, we can actually apply to the public guardian to do so, and they will remove them. Now, if you wanted to take both of them off, okay, you'd have to do a new LPA because they're going to be new attorneys. So yes, you can take them off if you have disputes, and you know, if you leave one on there and they're still okay, then you can use the same LPA. But if you wanted to take both of them off, then you have to start the process again and wait 20 weeks.
20 weeks.
But it is a possibility, you can do that. Yes, Anne?
Sorry. With a will, if they're your wishes and you pass away, can other members of the family who disagree with your wishes dispute it?
Well, if you've made wishes in your will, because we have to have executors, right? So the executor will carry out those wishes that you want, right?
Okay.
And in the will you have beneficiaries. Now you don't have to tell the beneficiaries anything about the will until you actually get grant of probate, and then they're allowed to see the official will if they require. And they also have the ability on a request to see the accounts once they've all been done, because they're beneficiaries. Now the wishes, the executor will carry out those wishes as per se in that will. Whether the family have disputes, not a great deal you can do about it, because they're not beneficiaries.
But if they are beneficiaries, then
If they are beneficiaries, then ideally you would come to some sort of an arrangement, because the last thing you want is bickering between, oh, I don't want that flower, I want that flower. So you come to a
It
compromise.
does happen though, and those
Oh,
compromises
yes.
don't always happen, do
Oh,
they?
it does. And it does, it's sad, and you can't flower up these things to explain to people. Now I'm Greek, so I have to try and translate what I think is the right words for you people to understand. So I don't speak the legal jargon as you would at a solicitor, because it's very, very crucial you understand what is going on and how it works. Yes?
Yeah, I've got another question on the will. Sorry, we're related. So I think
No, that's okay.
But if you have, for example, doesn't find out a case, but if you've got an heir as a child that you don't want to leave anything to, can you actually formulate a will that leaves them?
You can. If you've got children and a child perhaps is on drugs, or you don't want to give them anything, you could do a discretionary trust, but you could also do a separate document of wishes that you would say, I don't want to give any share of my estate to my son for any particular reason, and attached to that, if you can, you would put their birth certificate to make sure that that person relates to that person we're talking about. Because when I get a will, and someone said, oh, I want to give my watch to Simon, for example, what watch? And who's Simon? No disrespect, Simon, but there's no surname, there's no date of birth, there's no home address. It could be Simon from anywhere. And people don't realise making sure everything is documented and ticked in black and white is so important. Yes, Darren?
Quick question. Within your will again, so if you've written that out and it's all been completed.
Yes, I need you to sign it so I can send you the copy.
How important is it, with any updates? So if you buy a new house, or if you buy,
Updates.
yes,
Unless there are a lot of changes, we don't need to do a new will. I can do a document called a codicil. Now, a codicil will give you an update if you've changed address or you've changed beneficiary. They don't have to be, the witnesses do not have to be the same people who've originally signed your will. They could be anybody. But that codicil acts as part of your will and your updated wishes. So you don't have to do a new will if you only have little minor changes, but if you remarry or divorce, that's when you will do a new will. Okay? Does that all give you some idea of how this crazy world works?
yeah.
Brilliant. Thank you very much, Yasmin.
Is that okay?
It's wonderful. Thank you. If you've got any further